Big news out of the state of Illinois. We have a Illinois State Appellate Court has upheld the TRO, temporary restraining order, that was basically ordered by a lower court, state court judge in Illinois dealing with the recently enacted so-called assault weapon ban. Stay tuned. We're going to break this down because it gets a little geeky really quick on this case. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, New York Times bestselling author, and member of the United States Supreme Court Bar. If you haven't subscribed, please do so. We're trying to get to 100,000 subscribers to improve our standing with the social media algorithms. All right, folks. So big news out of Illinois. And we're going to break this down because it's a little nuanced. As you recall, in January of this year, the state of Illinois, through a hissy fit, and enacted effectively a so-called assault weapon ban, among other gun control legislation. The way they did this, by the way, according to the allegations in the complaint that I'm about to discuss, a case called Accuracy Firearms versus Pritzker. The way they did this is they proposed a piece of insurance legislation, referred it to committee, and next thing you know, that insurance legislation became a gun control bill, arguably without sufficient time and adequate notice for proper debate. But let's set that issue aside. After this law went into effect, there was a series of lawsuits filed, including one in state court in Effingham County, Illinois, which is the southern part of the state. The judge there entered a temporary restraining order saying that the newly enacted law violated the state, I repeat, the state of Illinois' Constitution, specifically the equal protection language of it, that said that under the Equal Protection Clause, you have to treat similarly situated people the same. You can't distinguish between people on a rational basis, basically, is what they're saying. And this lawsuit said that you had a fundamental right under the Second Amendment and beyond to protect yourself with firearms, and that essentially the way the law was enacted and its effect violated the state's Equal Protection Clause, which refused to recognize that violations of the right to keep and bear arms under Illinois law, state law, can only be done if it meets the strict scrutiny standard. Now, I know it's a little convoluted because the claim that was being advanced in the state court case was technically speaking not a Second Amendment claim, but was an equal protection claim that incorporated by reference Second Amendment concepts in law. Now, at the end of the day, the good news is, and that's what matters, is that the Second Amendment proponents have won so far. The trial court in Illinois said that under the Equal Protection Clause, the right to keep and bear arms was violated, and the reason why it was violated was because the state failed to satisfy the so-called strict scrutiny standard applied to cases such as this dealing with equal protection violations of a fundamental constitutional right. Now, there was a dispute at that lower level as to whether or not this is a fundamental right, but the lower court said, indeed, the right to keep and bear arms based on Nyserpa versus Bruin and beyond, and a series of Illinois Supreme Court cases found that the right to keep and bear arms was indeed fundamental, and they go over this. So at the lower court, the trial court said that this law was enjoined, at least as applied to the people, the long list of people, several hundred people that were listed as plaintiffs. The law was enjoined as applied to them because they sued, and the order enjoining the law was applicable to all the parties in this particular lawsuit. Now, that appeal was taken to the Court of Appeals, specifically to the Appellate Court of Illinois, 5th District, by the state of Illinois. And the Appellate Court in Illinois came out and ruled on the critical grounds of violation of the Equal Protection Clause under the Illinois Constitution, that indeed the lower court had it right, that the right to keep and bear arms is a fundamental right, and that it is incorporated within and through the state's Equal Protection Clause concepts. The state, by enacting this law and drawing distinctions between certain retired people and not retired people and who's allowed to carry and who's allowed to have these guns and so on, that violated the Equal Protection Clause, and that the state indeed had failed to satisfy its burden under strict scrutiny. Now, I want to digress just briefly. You know, when you hear the term scrutiny, tiers of scrutiny, rational basis, intermediate scrutiny, strict scrutiny, you run for the hills. Because when you hear those words, it is a euphemism. It is a metaphor for something very, very bad in the law for gun rights. That is, it is a euphemism for balancing away or balancing rights. Specifically, as the appellate court said, under strict scrutiny, you get to balance the important interest of the state in, for example, preventing mass shootings and crime on the one hand, against the rights of Americans to exercise their right to keep and bear arms and to protect themselves and their family on the other hand. Now, we've talked about this in Nysurpa versus Bruin, nipped this in the bud forever at the federal level, which says that strict scrutiny and any kind of scrutiny is not allowed when you interpret the right to keep and bear arms because it's about text, history, and tradition, not about balancing test. But here you have the appellate court as well as the lower court in Illinois, because they're applying Illinois state law, not federal law, but Illinois state law, they were applying strict scrutiny. But the good news is that despite that, they concluded that the state of Illinois had failed to offer any persuasive reasons why these laws made any sense to defend crime or anything like this. And they basically said, at the end of the year, violating the rights of people to keep and bear arms pursuant to the Equal Protection Clause of the state constitution, and therefore that fundamental right is being violated and the state cannot overcome that. So a major win here. Now, there's 2 points I want to mention specifically about this that's important. The first is I want to give you the example how the appellate court here in a 2-to-1, this is a 2-to-1 decision, by the way, 2-to-1 in our favor, but there was one dissenting judge that says he would have gotten rid of the TRO and allowed the law to go into effect, the gun control law. But here's what the 2 judges who ruled in our favor wrote about the balancing. It's very important to understand why you don't want balancing tests in Second Amendment cases or gun rights cases. Here's what the court wrote. This balancing analysis weighs the benefits of granting the injunction against the possible injury to the opposing party and its effect on the public interest. Here, weighing a fundamental right against potentially bruised egos or political pride is no contest. However, the effect on public interest is more challenging as we grapple with a fundamental right to keep and bear arms that allows plaintiffs to defend themselves or their families against a desire to protect the citizens of the state from the random atrocities associated with mass shootings. We hold no crystal ball allowing us to determine the likelihood of the potential harm if the TRO is granted, but we temper our lack of prescience with recognition that both interests, whether through the regulation of firearms or through the fundamental right to keep and bear arms, are based on increased desire to protect and defend loved ones in light of these horrifying and devastating shootings. Here we find it extremely relevant that no opportunity for discourse was provided to the citizens of this state that would allow for recognition of the competing interest. Terrible. I repeat, terrible. For the recognition of the competing interest in accomplishing what we believe is likely a common goal. No competing interest. The Supreme Court has made it clear that when it comes to fundamental rights, the balancing of interest has already been done by our founding fathers when they enacted the Constitution. So while, again, I'm not going to beat up these judges here metaphorically, because they're applying the state of Illinois Constitution in this case. And that gives rise to some differences in the law and to the legal standard and to the constitutional analysis because it's an Illinois state constitution they're interpreting, not the federal constitution. So again, they're doing what they need to do under Illinois state law. But again, understand that what they're doing is not good for the Second Amendment because the government will always be able to come up with the argument that says, well, our intent is to prevent crime. That's kind of the purpose of government. That's a purpose of government, right? Protect our liberties, protect our rights, blah, 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 protect our lives. But the bottom line here is that's the kind of language we do not want to see in judicial opinions. It's fine here because it's specifically to Illinois state statutory law and to the Constitution, but we generally don't like to see this. That is not good for us. But the good news is, at least in this case, the courts so far have ruled in favor of the Second Amendment right, saying that violating a fundamental right to keep and bear arms is so egregious and bad that the state cannot overcome that with any sort of compelling interest and whatnot. Now, the other thing I want to mention, and also have an idea now, I'm not an Illinois lawyer, and I don't know how this would work, but there's something very important for people in Illinois to recognize out there. So I'm looking at the last page of Judge Joshua Morrison's decision. He's a lower court judge, and here's what he writes about the scope of his order. He says a temporary restraining order is entered, etc., enjoining defendants or any administrative agency or law enforcement agency under its control from exercising any color of authority to enforce any and all the elements of the law. Okay. Here's the key language. Against all plaintiffs named in this action. I repeat, against all plaintiffs named in this action. He goes on to say the order is binding upon all the parties in this action, including all of their officers, agents, employees, and attorneys. Now, the reason why I mentioned this language of against all plaintiffs in this action is that obviously not all the gun owners in the state of Illinois are plaintiffs in this action. They're not parties to the action. Again, I don't know all the parties and lawyers and people involved or organizations involved in the Accuracy Firearms LLC case versus Pritzker that we've been talking about, but I would say that if I were a gun owner in Illinois, one thing I might consider doing, I'm not saying this is advice or legal advice or anything like that. It's something I would think about doing if I were a gun owner in Illinois, which I know I'm not. But if I were, I certainly would be asking myself whether or not I would want to seek a way to move to intervene as a plaintiff and to add myself as a plaintiff to the Accuracy Firearms LLC case versus Pritzker. Now, I don't know if that's doable or not, but certainly by looking at the list of plaintiffs, I counted quickly, it looks like a few hundred plaintiffs in that case. It's not clear to me why people could not be added as plaintiffs, assuming they're, gun owners and they allege the proper things that were alleged by the original plaintiffs. Again, I don't know how procedurally that would work in Illinois. I don't know the rules of that. I don't know any of those details. So obviously, if you're in Illinois and you're a gun owner and you're interested in intervening in this case, you might want to reach out to the people involved in this case, maybe the lawyers, maybe the parties, maybe gun organizations in that state. They may have some ideas, but as far as I'm concerned, if the TRO enjoining this law only applies to the parties in the state, I would think that it would be really cool to have as many Illinois gun owners joining that lawsuit as possible. I don't know if that's practical or realistic, but that's how I'd be envisioning it. Now, of course, don't forget, there, I believe, are another set of federal lawsuits seeking to enjoin this law permanently under the federal Constitution, specifically the Second Amendment's right to keep and bear arms under the Bill of Rights. So, it may turn out that those orders, if they're successful, might apply to all gun owners in the state of Illinois. One doesn't know because I don't think anything has happened in those cases just yet, other than there's some decisions about which judge is going to be hearing those cases. But again, those are separate and apart from the Accuracy Firearms case here that's pending in the Illinois State Court, as opposed to the federal cases that I'm sure we'll be talking about soon enough as those get going there in the state of Illinois. Okay, hope you learned a little bit something here today. We'll keep you informed as this Illinois assault weapon type cases are going forward and what's going on out there with these crazy gun control laws. But so far, so good. So far, so good in terms of our friends out there in Illinois. I hope they continue to do well and have success. And again, if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.